Are you ready, Miss Lucey?
Still unorganized, apparently. May it please the court. I'm Martha Lucey. I'm here representing Daniel Davis today. When I checked in earlier today, I kind of joked and said that maybe Mr. Mullins should go first because he's the reason why we're here. I did not file a reply brief in this case. State versus Albright is new law. I'm not sure what the court is concerned about. I would say Mr. Davis's case is the same as Mr. Albright. There was no final order for determination of reasonable ability to pay. Excuse me. The clerk of court has assessed court costs that we can see on this record. If the court looks at the docket, attorney fees are now on the docket also, along with victim restitution. DOC has filed a restitution order, or a plan of restitution. There's two different plans. Mr. Davis has paid money. According to the priority, it'll go to victim restitution first. I think the difficulty that we have with implementation of the Albright decision is not about the decision itself. It's about the administration of what has occurred for years where there has not been orders for reasonable ability to pay, and the clerk of court is tasked with implementing restitution, implementing the judgment, sending information to Department of Corrections, to Department of Correctional Services, and that's where the restitution plans come from. If there is not an order that is a final order on this back end, clients are still being assessed and money is taken. Judgments are being enforced.
Albright says that those orders are that's not enforceable until you get to the final orders. So what language, if you were writing the opinion, what language do you put in to solve this administrative problem?
I think that there's several problems that an opinion alone is probably not going to solve. I think that we have 99 experiments that are still going on. Some counties have done it better than some others.
We'll take judicial notice of that.
Yes. And the bad thing is that this court doesn't see all of that stuff that happens behind the scenes because there's no further orders. An example, Dubuque County. If there's filing fees and court reporter fees, and all of those fees get added into this electronic docket, but the order says the defendant doesn't have the reasonable ability to pay that. What happens? And in Dubuque, they have like a placeholder. They say it was paid with a code, so it's somehow tracked for them. In other counties, nothing happens. It still says the defendant owes this money because when trial information is filed, that $100 goes automatically on that docket. And then what do we do? So, I mean, I think there's a couple things. I disagree with the state. This is not an administrative action or exhausting administrative remedies because 17A does not cover the judicial branch. The judicial branch is not an agency for 17A. This is not a DOC problem. This is not a DCS problem. Unfortunately, this is a problem of software potentially from the judicial branch. And if an opinion, get back to your original question, I think the opinion has to say, if you're going to order any amounts, it better be a final order. Because if you look at this judgment entry, it says, defendants assess the fees of the court-appointed counsel and the amount approved pursuant and court costs in this matter. There's no amount here. And if you look at it, is that a temporary order? He's assessed it. Should he actually be assessed that amount yet? Or should it be defendant may be liable for...
Should these appeals be dismissed as premature or not ripe when there hasn't been a final order yet?
Then if you go that route, I'm going to answer your question with a question, and then I'm going to try to answer your question. If you go that route, defendant has no remedy whatsoever because it's not an administrative action. It's not a 910.7 action because there is no restitution plan. So what do you modify?
I'm sorry, can you repeat that last part?
It can't be a 910.7 action because there's no restitution plan. Not even a plan of payment, but a restitution plan.
So Albright says these amounts are not enforceable because there hasn't been a final restitution order, but you're saying is just having them on the docket is creating problems. It's going to look like they owe the money.
And they're getting snagged, aren't they?
They're getting snagged. They're having to pay. So Albright says they're not fine. You don't have to consider the reasonable ability to pay till it's a final order. And I don't take much. I don't have a problem with that. But we have Albright, and then all of the cases that this court decided after Albright, Petty, Koval, Headley, I don't know. I looked at Westlaw yesterday. There's 47 cases that cite Albright for those head notes.
You had one little word that I thought was interesting, may. I think that actually, I'm trying to process that in my head when a sentencing order, if it would say you may on all of the following items, do you think with our system then that the clerk's office and all the people who make that software happen, that they would not feel compelled or the program would not then automatically start that process of collection?
I think clerks enter what the judge says. And if they don't, then the judge is really going to say, hey, but that's not what I said. It's may. You may have to pay this. But subject to a final hearing or a final order, we don't know that. So when the court says you are assessed this.
It reminds me of a sentencing order or a plea, a guilty plea, when somebody pleads guilty and say they're taking it down from a B to a D, and we know all the fines and the amount of time. So all the warnings are in there for a D, but it's a plea, not a sentencing. And so this client signing off, I know I might get dinged this much for money. I know I might have to serve, and some of those we all know are mandatory. You're going to get 5 years. But anyway, I think that in that situation, nothing gets triggered until there's a sentencing order, correct?
Right.
So it's similar to what your argument is. It's actually, I think, a pretty clever little word you thought of there, may.
It's just may. And,
Can I follow up on that thought? And this seems like we're spitballing more than having an argument. But in that light, so let's say you change the word to may in a sentencing order. Somebody is committed issues. They go to Oakdale for processing. They're in a facility at that point. In your view, how would that work to where you go from may in some sort of conditional or provisional sentencing order to a final order, and would the defendant then have to appear and be transported from a facility to have a more final order? I'm not sure logistically how this would work out according to your suggestion.
And I think that you kind of hit something on the head that I've had trouble with this court's holding in Albright. And don't get me wrong, I think Albright is a huge step forward for indigent clients. I'm not sure how you have a final order and then supplemental orders without having another final order. But right now is that you have a judgment entry for a sentence that says you are fined and you are sentenced to 5 years indeterminate in DOC custody. You don't have final numbers, so we don't have a final restitution regarding the discretionary restitution. Just like sometimes we don't have, in this case, they didn't have victim restitution at the time of sentencing. That was entered later. That was $2,000. For my clients, $2,000 is a ton of money.
Is the fact that DOC is collecting from his prison account anything we can do about in this appeal?
Yes.
How?
Because where does DOC get that number from? DOC gets that number from the court. 910.5 says that the court is to forward the amounts, and then DOC is to do the restitution plan of payment. Someone should have named them the same things. So DOC doesn't have that number without getting it from the court.
But the victim restitution isn't subject to a reasonable ability to pay. But so we're talking about $405, or is there more than that?
Our record shows $405, but if you look at what the rest of it is, there's some more. And that's in the financial page. Mr. Mullins and I both looked at that yesterday.
But the DOC could collect the victim restitution part anyway.
Yes, and that's going first.
Right.
And in this time period, with what Mr. Davis has for financial means, they haven't reached this $400 yet.
So
but they're gonna.
There's a lot of opinions on appeal, that are pending where this cost issue is part of it, but they've also appealed from the judgment. Mm-hmm. Maybe they're challenging their conviction. What's the best way to carve out this piece? If we say that, hey, you don't have a final order restitution, that's not enforceable, and it's not ripe for appeal, what do we do with that when it's bound up in a case with several other issues?
If nobody is trying to collect it because the court did say, hey, you're assessed this, and it's clear that you may be responsible in the future, but we don't have a final order, it's not part of the direct appeal. So when a final order comes, and if there is an issue that needs to be addressed, there is appeal of right from that final judgment on restitution. I don't think this court sees a ton of restitution appeals. There are some. My office does them. But if you actually have a full determination of reasonable ability to pay, it's probably not going to be an appeal from that.
We had that $1,900 paper study guide, right?
But that was victim restitution. And there is a difference between victim restitution. I think we all see appeals from victim restitution way more frequently than we're going to see them on the reasonable ability to pay. Back to Justice McDonald's question, are we going to have to transport people? Maybe, if the defendant wants to appear. He or she may get to transport. There's a footnote in Albright that talks about, a defendant can waive his or her appearance. There are counties where you're probably seeing where people are filing new financial affidavits. They're using a form that sort of looks like the IRS form, income, debt, so the court has this information. The difficulty is that oftentimes the sentencing court is never going to be able to have all of the information. But there's oftentimes, when we're looking at the information that's missing is just attorney fees, we already know that a lot of the indigent clients don't have the means to pay that back, especially if they've gone to prison. So the judges are saying, hey, look, I'm doing a final order right now. This person does not have the ability to pay this.
Can the district court on its own motion schedule a 9-10-7 hearing?
I believe the code says that they can.
So if that's true, could there be some sort of procedural fix where the rule would be simply that none of these issues are appealable, the DOC order is not enforceable until such time as there's a final order entered after a 9-10-7 hearing, scheduled by the district court as a matter of course? Maybe it's 60 days after the date of sentencing, something like that.
910.7 would have to be amended because it's a modification. And you don't do a modification if you don't have something to modify.
You do video, appear by video conference?
I think potentially you could. I don't know how well any of that is working. Honestly, I don't know the last time I've heard anybody appear over ICN. I know that there are some prisons and some jails in Iowa who do have some video capability. We have Skype, but does the judicial branch have that ability?
I think it's usually like on a Monday morning after a bunch of arrests over the weekend, and they do initial appearances that way. But I think you're correct about general hearings, not so much.
And I don't think that the prisons, I don't know if they have that ability to do that. There has to be a workaround, and I would certainly urge this court not to say these clients have no means of challenging when the state of Iowa is taking their money. Thank you.
Mr. Mullins?
May it please the court, will not be the first time nor the last that I've been told that this is all my fault. I would like to offer the court the opportunity to clarify Albright. Albright, as you know, reversed a premature reasonable ability to pay determination, but also said that orders in advance of the final order of restitution are not enforceable or appealable. I think that's probably overbroad. It can be correct in some instances. And I'd like to draw the court's attention back to 910.3, which explicitly contemplates that there may be instances where all of the amounts are not available, and so the court may issue, it says in fact that if the full amount of restitution cannot be determined at the time of sentencing, the court shall issue a temporary order determining a reasonable amount for restitution identified up to that time. Then, of course, as you know, at a later date, as determined by the court shall issue a permanent supplemental order. So the code contemplates that there would be an order of a reasonable amount of restitution, and I suggest that although it's a temporary order, it would be enforceable. The question then is it appealable? And by appealable, I'm using that term surgically. I use that as synonymous with a direct appeal. I suggest it's not. I suggest if there's an avenue for review by another tribunal, it would probably be like any other order in advance of a final ruling. It would be interlocutory, request for discretionary review, for example.
And I don't disagree that one can read Chapter 910 the way you're talking about, and that, but didn't we say in Albright held that what Ms. Lucey is describing really shouldn't happen? In other words, until there's a reasonable ability to pay determination, which can't happen until everything is known, there shouldn't be an enforcement of a restitution in the broader sense of restitution against the defendant. Didn't we say that?
Well, you did, but I'd like to take some care in fashioning what we're talking about. So take, for example, State v. Haas, where the question was whether she had the reasonable ability to pay attorney fees. And I can't recall, much to my shame, since it was my case, whether there were other costs involved, but the fighting issue was over attorney fees, and the district court made its reasonable ability to pay determination. And so that, in some respects, would be considered a temporary order, like a 910.3 order. So if what we're talking, I think my concern with Albright was that it just swept too broadly and says, if you're lacking one piece of information, that you cannot make a reasonable ability to pay determination over any of the other issues for which you do have that information. I think in that respect, that's probably where Albright might need to be. I
think conceptually, didn't we say in Albright that it's really not fair as a conceptual matter, and we thought this had some basis in the statute, to say that you can make a reasonable ability to pay determination until you know what all of the debts are going to be?
I think because in Albright, all of the debts were all of the debts. That was the entire list of components of the discretionary matters. That was the stuff that was not known. But if, for example, you have a couple of other items, in other words, some of the amounts are not yet known, as 910.3 contemplates, you can determine, or a district court can determine a reasonable amount for restitution up to that point, and that would be a temporary order.
Isn't that going to be a mess for the clerk's office? I don't know if it's ever possible to have that first order truly have everything, because as you're standing there, as you know, Ms. Lucey, if she were in district court standing there representing her client, that clock is ticking. She has not yet submitted that bill to State Public Defender's Office. I think it's impossible to have those numbers at the time of sentencing. So then are you suggesting that the clerk's office should go ahead and start to mobilize with what they got? So there's some stuff being collected and then other stuff down the road?
No, I'm not. Because while I have no difficulty with the clerk exercising its statutory obligation to collect that information, as it must, and transfer it back to the district court, unless and until the district court signs off on it, they shouldn't be enforcing it.
Right. So there, would you address her suggestion, Ms. Lucey's suggestion about just that simple word of may? Would that make a difference in your mind?
It does. It's one of the suggestions that I proposed in the briefing, but that's not incidentally the way the Court of Appeals is looking at it now. The district court, or I'm sorry, not the district court, but the Court of Appeals has been reversing rulings where it's quite plain from the face of the sentencing order that these matters are yet to be determined, and it could end up being 0. And so I think what has occurred is, by virtue of Albright and the way we've been trying to work our way through it, we have, to individual defendants' detriment, added this extra loop where now we're adding appellate attorney fees before this case, whether it gets dismissed as improvidently granted or it gets reversed for a hearing to determine the defendant's reasonable ability to pay. It's going to go back to the district court, which, by the way, I think is the proper venue to address this matter. I do take some question to the notion that you cannot have a 910.7 hearing in advance of the final order of restitution. I don't believe that the statute has quite that much rigidity to it. But I do draw on some notions of, say, for example, error preservation. If we are talking about a question that has been definitively resolved by the district court and the facts and the figures are known, well then sure, you take it up on appeal because error has been preserved. But particularly here, where we don't know a lot of these numbers and we don't know for sure, I don't anyway, know whether the defendant is in custody, whether costs are accruing or not, I think it's the district court that would be the better venue to resolve this, because they'll have the facts and the figures there, and, by the way, can provide whatever relief the defendant needs more quickly than...
I mean, can't we read 910.3, the language you quoted about temporary order, in order to reconcile everything, to say that the temporary order can only include things that are not subject to the reasonable ability to pay determination, like victim restitution or fines, penalties, things like that. But they can include, but court, I mean, the problem here is court costs were included without that determination. I'm finding some difficulty understanding why, for example, let's say you know that there is a $40 court reporter fee, and that amount won't change.
It will if something gets contested.
Well, unless it gets contested. And, of course, we are in something of a vortex, because with every appeal, costs do keep accruing. But at least as I understand 910.3, I don't see why since it is an amount known, I don't see why the district court couldn't, if it has a complete financial the defendant's complete financial picture, might not be able to say, as to that, you have the reasonable ability to pay it. All other amounts are as to be determined, and you may be assessed those costs. That has to be left for another time.
Yeah, but here's what, at least speaking for myself, here's the mental process I was going through in Albright, which is, well, you have these items like the jail fees and the court costs that are subject to the reasonable ability to pay screen. But you might have some victim restitution that's lagging out there that's going to come in a month later. When that victim restitution comes in, it may be so large that it dwarfs these other items, and at that point you realize the defendant doesn't have a reasonable ability to pay the court costs and the attorney's fees.
And I have no difficulty with the notion that under 910.7, those amounts would be altered to reflect the more current state of affairs.
That's an interesting regime, but that doesn't seem to me what we approved of in Albright.
And that, in part, is why we suggest that Albright ought to be clarified. I do recognize that, sometimes district courts and all can be something like trying to herd a group of wet cats into a wet bag. And I submit that I'm not standing here suggesting that the district courts, that we have to be enforcing on orders in advance of a district court's rulings. There may be some avenues to make this system work. My proposal is that this is one that works, that's within the frame of 910.7 and at least has the patina of legislative intent, that there be this notion that you could make a preliminary temporary determination with the information that you have, and your reasonable ability to pay determination is confined to that notion. So you're not asking somebody to pay for something that they don't already know. And then if, for example, so that would be an example of an enforceable order. Then the question is, what happens when mistakes have been made? If a district court clerk is sending out a dunning letter, I don't know if they do, or if the Department of Corrections is taking money out of an inmate's account. And by the way, if the Department of Corrections is doing that, then it is an administrative proceeding that they can address that matter there. And then, suppose, for example, the district court clerk is doing something that an individual feels that they should not. Well, the answer then is to go to the district court and get a final ruling. Get a ruling and so that you have a judgment to enforce. Now, if one of those subordinate agencies has done something incorrect, the question is, what's the nature of review? How do you get that review? And I suggest that under 910.7, the best form for doing so is the place closest to the error, the one that has the best access to the information and can resolve it at that time. But if that has not worked out, then you file an application for discretionary review, and if there's been an error, this court or the Court of Appeals can take it up and resolve it.
That adds another layer. I'm thinking that if the Department of Corrections or wherever it is starting to grab money from the individual, it's because of a court order.
They ought to be if there's a court order.
Shouldn't we go back to that stage to try and correct this instead of throwing in yet another layer and making them go through judicial review? And because it sounds to me like Ms. Lucey is saying that her client, whether it's this case or other examples, are being snagged before the final order. That's where I think the problem is.
And I would tend to agree that if agencies or clerks are acting without authority, then that is an error. It's what I'm further suggesting is the mechanism for review ought not be direct appeal, but rather discretionary review.
So could we clarify and indicate that absent an order from the district court, no order with respect to costs shall be enforced? So as I understand it now, at least mechanically, at least when I was on the district court, the Department of Corrections would enter these plans, they would file them, nobody would review them, nobody approved them, and then they were being enforced by the DOC, and every once in a while you'd get a 17A action. I think we might have had a case, Morris, where somebody actually challenged the enforcement. But why can't we just make the rule be none of this is enforceable until such time as there's a order or a 910.7 hearing or something that indicates it's been approved by the district court?
And to use the parlance of my peer group, I'm fine with that.
So if we said nothing is enforceable or appealable of the items that are subject to a reasonable ability to pay determination until there's a final order of restitution, you're fine with that?
Well, as I was attempting to explain, I think that is a little overbroad, because my position is that there are some temporary orders that would be enforceable. The mechanism for appeal would be as I had suggested. But as to those other orders that in advance of the permanent supplemental order or something that is purely temporary, any of these things statements that get filed and that there's no ruling or district court action upon, those for sure are not appealable because they're not enforceable.
Wouldn't Justice Waterman's suggestion be a little bit of a brighter line? a little bit cleaner path, perhaps? I think we all realize there's a lot of confusion right now. So what would you suggest would simplify? Because I do think that what he proposed seems a little maybe easier to actually put into action at the district court level.
Okay, so if I had to disregard the reasonable amount of restitution identified up to that time,
I just think he mentioned trying to make it more of the way he worded it, I thought was simpler than your proposal. You're trying to pull out different things that can, let's go ahead and get started on pulling this out. I think that's where the whole problem is. Money's getting pulled out, and we don't have a final order yet. So I guess I'm looking for a brighter, clearer line instead of more of what we've already seen.
I guess I would say that the district court clerk shall not enforce an order absent the district court's determination of a reasonable ability to pay.
You can sum up.
I have nothing further to add other than that we ask this court to revisit the language of Albright and dismiss this appeal. Thank you.
Rebuttal?
Justice Mansfield, what the state is suggesting is close to what I suggested in Albright, that this court did not ultimately decide. If you have a temporary order, I suggested, and if you're going to go that route, the reasonable ability to pay determination has to be made at that time of the temporary order, or you're going to run into constitutional challenges. Because
And not if it's the mandatory items, right?
right. Those don't.
So, I mean, what if we just say that the temporary order can only include mandatory items? I realize that maybe isn't what 910.3 says, but at least it allows that provision to be reconciled with Albright.
I didn't bring 910.3 yet, I don't think. If you look at 910.3, if I recall correctly, now that's off the top of my head, and I do have it here. Yep, thanks, I got one too. I've always questioned whether further supplemental orders, if necessary, can be filed. But you have a temporary order. Do you actually have a permanent order and then supplemental orders? Or is it permanent, supplemental order being one thing? That we have a temporary order, and then we only have a permanent order, which would be the final order. So if you go with the idea that with a temporary order, if we have victim restitution, pecuniary damages, fines, fees, surcharges, we can order that because it's not subject to reasonable ability to pay. But if you're going to have a final order that's going to be enforceable at any point in time to avoid constitutional issues, you need to have a reasonable ability to pay. Where I'm concerned is that if we go back to the old days where there's never a reasonable ability to pay determination, there's never a final order, there's never a follow-up, no one's ever even considered whether the client has any means. It goes on, and it's enforceable, and people collect it. I don't think Albright goes too far. Maybe in order to fulfill that, we need to change, we meaning the judicial branch needs to change the administration portions. Haas is sort of an anomaly out of all of the cases. Haas was a driving while barred. I don't believe that there was victim restitution. There may have been a fine, unclear. But the distinction in Haas was that, if I recall correctly, I hope I'm right, the district court ordered that attorney fees be paid. By the time it got here on appeal, the district court said, oh, no, wait a minute. I take it back. There's nothing to see. I didn't really mean that. So there was nothing for you to say reasonable ability because the order had been taken back.
Can I ask you a question? And maybe some of the confusion is coming from the nomenclature we use. So you say a temporary order, but to me it seems more like a partial order. but it's permanent and final as to a piece of it, right? So if I'm a sentencing judge and I come in and I'm getting ready to preside over a sentencing hearing, the attorney has a timesheet so I can calculate what the fee is. I can go ahead and make a reasonable ability to pay determination with respect to attorney's fees, let's say. And my order is final as to that piece, subject to modification in a 9-10-7 hearing if we learn additional information, but it's not temporary. It's just partial because it's not covering the complete scope of sentencing, which seems like you should be able to make these categorical determinations order by order as they come in. Does that make sense?
And that's what I had proposed at Albright. But where we ran, I think where this court ran into the problem is that right now you can afford to pay the $100 for attorney fees. And then, lo and behold, victim restitution comes in 2 months from now, and victim restitution is $42,000. Well, I don't think that $100 is really within the means anymore. So if you order it now, things can change, and that's why what the court said in Albright was we have to have the total amount known. Because if you're going to...
I'm just going back through the appendix again, so I can understand what's sort of wrong in this case from your perspective. There's nothing, I don't see anything wrong with the actual sentencing order.
The sentencing order on page 17 of the... I see that I'm over time. May I continue?
Yeah, I'm paying for it, so.
Please do.
Okay. On 17, it says, defendant assess the fees of the court appointed counsel and the amount determined by the public defender, in addition to any court costs in this matter. There's no amount.
Okay, I see. That's the problem. Okay.
And then when you look at the DOC restitution plan, it includes that.
Yep. And all court. Okay. That's the problem.
You can sum up.
I would ask that this court not dismiss Davis's appeal. He'll have no other means to challenge this. He will have no counsel, and I don't think that that's what this court had in mind when they determined Albright. Thank you.
Very good. Thank you. Davis, Lyon, and Stocky are submitted. Bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.